Jai Hind. Dear friends, referring to you now the amended provisions under the indirect tax laws applicable for our CA, CMA and CS for the forthcoming exam of May 2023 or June 2023 are as follows. Presenting here the important circular of the CBIC with regard to para number E of Schedule 2 to the CGST Act, namely agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act which is specifically declared as a supply of services which need more clarification, because in the industry there is ambiguity arises which one is called as a consideration, thereby it attracts the GST, which type of refraining from an act to do a particular thing or obligation to refrain from an act or tolerating an act or a situation, which one is taxable, which one is not taxable under GST, becomes so difficult to apply practically, which has been now crystal clearly explained by the CBIC in the given circular number 178/10/2022 GST dated 3rd August 2022. Here we have elaborate explanation. First they explained what do you mean by this particular terminologies, where we have three terminologies. If you refer here, my dear sir, you will understand this. Agreeing to the obligation to refrain from an act is one area. Other area, agreeing to the obligation to tolerate an act or a situation. Another area here is agreeing to the obligation to do an act. What it says actually, I am not now presenting immediately whether taxable or not. I am now referring to you each point out of these 3 points. Each point I am taking first point, second point, third point, and explaining the examples how to understand. First, agreeing to the obligation to refrain from an act, how to understand it is presenting here are as follows, my dear friends. If you refer here on the goods and services tax, I am bringing to your notice. First point, agreeing to the obligation to refrain from an act. How to understand this first point, which is declared supply of service under para E of Schedule 2 to the CGST Act, which you are already aware of it. Presenting here, agreeing to the obligation to refrain from an act, stopping oneself to do, not to do something, stopping oneself not to do something. Agreeing to the obligation to refrain from an act. It is to be understood in the following manner. In the case of non-compete agreement, take one example. Non-compete agreement means one person saying to the other party, I am not going to do this. That means to say that there is no express or implied contractual agreement to make the payment for not doing something. So in this regard, non-compete agreement, one party is not honoring the contract made with the other party. In such case, how to understand agreeing to the obligation to refrain from an act? If you look here, my dear friends, you will understand this. I am as a builder, I can able to construct here. See here, if you refer in the given case, especially if you refer, I can able to construct something more on that particular floor, because I am a builder. I have permission to construct almost all 50 floors. But if I construct the 50 floors as a builder, the neighboring residential area, they may not be get sufficient sunlight, resulting that they may affect. So that neighboring residential unit or the neighboring people approach me by saying that, hey Mr. Builder, do not construct more than a particular limit. You stop at this level. By not constructing the further floors, though you may be having the right to construct, do not construct it. For not constructing that, we are going to pay some compensation to you. As a result, there is a flow of fund or money from these neighboring residential units to the builder, because builder refrained to do something, not to construct something more. Though he may be eligible to construct something more floors, but not constructing, not to construct. For not doing so, we will pay something to you. It is one of the example with regard to agreeing to the obligation to refrain from an act. Further, one more example here. If you refer in one side here, you will understand, my dear friend. Industrial unit. Here there is industrial unit. They are competent to produce product by making some noise in their factory. Obviously, when the factory machineries are functioning, there may be some noise. School nearing to that, attached to that, affecting because of that noise. Therefore, school said, hey Mr. Manufacturer, especially during these hours, our important classes are going on. If you operate your machines, our children may not be able to concentrate in the class. Hence, we are requesting you not to operate your operations, at least for few hours, especially on these days, on these hours. Manufacturing unit agreed not to function by collecting some payment from the school, agreeing to the obligation to refrain from an act is one of the example. Further, my dear friends, second point, agreeing to the obligation to tolerate an act or a situation. How to understand this? Agreeing to the obligation to tolerate an act or a situation. How to understand this? With example. I am not telling by jumping into tax liability is there or not. First, to understand the terminology, what it represents. The first point I referred, refraining from an act. Now I am referring agreeing to the obligation to tolerate an act or a situation. Tolerating an act or a situation. How to understand this? Look here. In the given case, my dear sir, there are so many shopkeepers. In front of them, exactly in front of their entrance gate, there are so many hackers are selling their small petty items. The shopkeeper permitted them to keep in front of their shops the products what they wanted to sell, but with an agreed amount monthly to pay something. For example, look here, hackers to operate from the common payment in front of shops against a monthly payment by hackers. So whatever payment is paying by hackers to the shopkeeper is shopkeeper tolerating an act of the hackers, though they may disturbing to the customers entering the shop, he accepting, he tolerating it. So one of the example. Further, my dear friends, if you refer here, housing society, a residential welfare housing society is tolerating act of the school, where the school is using the loudspeaker for their prayers, for their programs, which is very much noising to the residential house, which is very adjacent to the school, near to the school, attached to the school. In that case, such a housing society is tolerating, okay fine, you please proceed, use your loudspeakers, we will accept it, but we pay something to the society. So the school is paying some payment to the housing society, where the housing society is tolerated the act of the school, where they are using loudspeakers. So one of the example is obligation to tolerate an act or a situation. Referring to the point number 3 here, my dear friends, the point number 3, if you refer here, you will understand the point here. One by one I am referring here. Here if you refer, point number 3, agreeing to the obligation to do an act. Agreeing to the obligation to do an act. Dear friends, here there is a very big factory in this premises. There is a very big factory. This factory is producing various types of heavy duty products, and the production and the entire production process well within the control of emission control system only. For the safety measurement purpose, extra precaution purpose, nearby that particular industry, housing society, a residential welfare association made an agreement with the manufacturer saying that, hey mister, you please install the very good pollution control system. Though that particular products produced by the manufacturer not in a position to produce the pollution, not producing well within the emission control only. In spite of that, by taking the precaution by the housing society nearby to the factory, saying that you please install the pollution control equipments. So agreeing to the obligation to do an act. So housing society said, therefore we are installing a extra emission control system, where the housing society paid something to the industry, that particular manufacturer who are near to that particular residential welfare association. In that case, it is also be called as agreeing to the obligation to do an act. Now I am referring to you, my dear friends, the points after I explained to you the points of 3. Refrain from an act, tolerating an act, obligation to do an act. This I am presenting furthermore, my dear friends, for a kind consideration. Example by example here. Liquidated damages, where there is no express or implied contractual agreement, we just made the payment. In the given case, if you refer here, the breach of contract, one person is not complying the agreement made with the other person. Contract has been liquidated, means cancelled. Liquidated damages, such a liquidated damages is not expressly impliedly incorporated in the agreement. In spite of that, the person who defeated that particular agreement is making some payment to other party. Is it a consideration will attract the GST? That has been explained by the CBIC in our given circular in the following manner. If the payment is paid to the other party, in the given case, the payment is paid to other party, amount paid due to the breach of the contract, and there is no agreement express or implied by the aggrieved party receiving the liquidated damages to refrain from or tolerate an act or to do anything for the party paying the liquidated damages. Such payment do not constitute consideration for a supply and were not taxable. One thing is very clear, such a contract where there is no express or implied clause mentioned to pay something on account of breach of the contract, there is no express or implied contractual agreement. I have been cancelled the contract, I am responsible, therefore I am paying to you something, you take. I like to pay, let us say 2 lakh rupees, you take it, which is not mentioned in the contract. On account of cancellation of the contract, the person who defeated that contract has to make the payment to other party so much. Such money, such clause is not mentioned in the contract, which is also be called as unliquidated damages. That is, liquidated damages what the one party paying to the other party is not specifically mentioned in the contract. In such cases, that is a mere flow of payment does not constitute consideration. If it is not a consideration on account of breach of a contract, liquidated damages paid one party to other party is only a mere flow of payment but does not constitute consideration, resulting that not attract GST. It means what? Other way around, if you refer, it is taxable. If a contractual agreement clearly mentioned A and B are made a contract, A is a supplier, B is the recipient, B is breached that contract, B is supposed to be paid 2 lakh rupees to Mr. A. That has been very clearly written in the contract on account of breach of the contract. In such case, that will be constitute consideration. Here there is no contractual agreement, express or implied. In that case, just mere payment on account of breach of contract, such liquid damages, only flow of payment, not a consideration. What is not a consideration? You cannot charge GST. Further, my dear friends, under the liquid damages, one more point I am referring here. Very important to refer this area. Late payment, early termination of lease, prepayment of loan, amount forfeited on cancellation of service by the customer. Especially in the given case, if you refer, sir, you will understand. As contemplated by the contract as a part of the commercial terms agreed by the parties, constitute consideration for the supply of a facility, acceptance of the late payment, early termination of a lease agreement, of prepayment of loan, and of making arrangement for the intended supply by the tour operator. This and all, late payment, early termination of the lease, repayment of the loan, this and all amounted to forfeited amount, this and all contractual agreement mentioned in the contract. Therefore, such payment, even though referred to as fine or penalty, are subject to GST in case where the principal supply is taxable. For example, my dear sir, I have taken the loan from the bank. Is a money transaction, not attract GST. Principal supply, no GST. When I am making the payment of interest, no GST. Delay payment charges for that particular loan payment, delay payment charges, penal interest, late payment, also be not taxable because my principal supply is exempted. If the principal supply is taxable, then late payment charges also be taxable. For example, I sold my laptops on credit basis for 1 month. If not paid within 1 month, the buyer has to make the payment, delay payment charges. In that case, the supply of laptop is taxable supply, main supply is a taxable supply. In that case, when I received late payment charges is also be taxable because my principal supply is a taxable supply. Further, my dear friends, referring to you the points explained by the CBIC in the given circular, which I am elaborating by just presenting, look in understandable manner. Referring here, compensation for cancellation of coal blocks has been explained by the CBIC by stating that in the case of a coal block where the natural resources owned by the government allotted to the allottees, where the allottee is enjoying using that particular extraction of the coal, there the government is cancelling that contract. On account of cancellation of the contract, the license holder, where he will go, sir, you have given to me the license to extract the coal for 5 years. Now within 3 years you are cancelling me. Unfair. In that case, government is making the payment as a compensation to that particular allottee, previous allottee, the earlier allottee, to whom the license was allotted, now got cancelled. On account of cancellation, government making the payment some cancellation charges, namely compensation to that particular allottee, license holder. Such compensation will attract the GST. The law of the land here says that, is it there in the contractual agreement? It is not there in the contractual agreement. To make the compensation, to make the payment of compensation on account of cancellation, the government should make the payment to the allottee. Such a contractual agreement is not there in the license. In that case, but compensation has been paid on account of statutory obligation under the Coal Act. Under the Coal and Mines Act, the statutory obligation, under that obligation the payment has been paid, not as per the contractual agreement made between the license holder and the government. Allotment of coal taken place. In that agreement there is no compensation clause, but the compensation paid to that particular allottee to whom the license has been cancelled is as per the Coal Act in that case, or as per the Supreme Court of India judgment. Thereby we are making the payment of compensation, which is not a consideration, which is only a payment. Therefore I present it here by referring for a kind consideration. The compensation was given to such cancellation not under a contract between the allottees and the government, but under the previous or under the provisions of the statute and in pursuance of the Supreme Court of India order. It is only under the provisions of the statute and in pursuance of a court order, the Honorable Supreme Court order. Thereby the compensation has been paid. Hence, such compensation is not taxable because it is only a mere payment but not a consideration. Further, my dear friends, explaining to you here, cancellation of a check, charges charged by the banker, cancellation charges on account of check bounce, check cancelled. After issue the check got bounced in the bank because insufficient fund, because no signature has been made or wrongly signature has been made or overwritten something on the check, something has been taken place, resulting that the check got bounced in the bank. I issue the check. Then in that case, banker charging penalty, charges. Is it for tolerating an act or refraining from an act or agreeing to do an act? Neither three. In fact, it is not for tolerating an act, not to do anything next time, not for tolerating an act. It is not for tolerating the act. You get my point, sir? It is for not tolerating an act. For tolerating an act, different from not tolerating an act. So, referring here, it is not a tolerating an act, resulting that the check bounce charges is only mere payment but not a consideration, not attract GST. Reading as follows, the important point here. The fine and penalty that the supplier or a banker imposes or dishonor of a check is a penalty imposed for not tolerating the act, for not for tolerating an act or a situation, but a fine or penalty imposed for not tolerating, penalizing and thereby deterring and discouraging such an act or a situation. Therefore, check dishonor, fine or penalty is not a consideration for any such service and not taxable. Simple to say, check bounce charges is only for not tolerating. It is not tolerating, not to do next time. Therefore, a mere flow of payment, it won't come under the tolerating an act. Hence, not a supply, not a attract GST in the given case. Further, my dear friends, simple to say, check bounce charges charged by the banker, no GST. Further, my dear sir, referring here, penalty under the breach of law, penalty where there is a breach of law, or otherwise I can say that fine and penalty chargeable by the government or local authority imposed for violation of statute bylaws, rules, regulation are not available to GST, are not leviable to GST. Meaning what? Simple to say, my dear friends, if there is a delay in payment of the GST, the penalty has been imposed by the government under the GST, under section 122 of the CGST, penalty has been imposed. Such a penalty is not a consideration, or otherwise on account of violation of statutory provisions, let us say the Ministry of Finance or the what we can call as the Ministry of Education Board charges penalty on the school where the school has not been functioned as per the School Education Board norms. So these and all the penalties levied on account of violation of statutory provisions, or if there is violation of traffic rules, the traffic inspector charges the penalty. It is not to tolerate an act, it is not to repeat the act. Therefore, in that case, such a penalty is on account of violation of statute, bylaws, rules, regulations. Therefore, the penalty paid is only a payment, cannot be a consideration, which is not attract GST. Further, my dear friends, referring here to you, let us say employees so dedicatedly working in the organization, nowadays you come across so much of retrenchment taking place even across the globe for the employees because of the non-availability of funds or whatever may be the reason. Now what happened here in the given case, for example, my dear sir, forfeiture of salary or payment of bond amount in the event of the employee leaving the employment before the minimum agreed period. For example, I qualified as a CA, I made an agreement with the company, MNC company, where I promised by writing in a bond, I will work with you for 5 years. On account of leaving within 5 years, I will pay to you my 5 months salary as compensation. Is a very clearly a clause mentioned in this particular bond. Okay. Now, within 2 years, I got very good opportunity, therefore I am leaving the job. In that case, the employer collecting from me 5 months salary. Let collect. By collecting it means the employee paying to the employer. In return, employee not getting anything. That means there is no reciprocity, only a payment. Payment without reciprocity is equal to only payment. Payment cannot be called consideration, therefore no GST. That means forfeiture of salary, or even though there is a payment of bond amount where the contractual agreement employer-employee made it in writing, where premature or before completion of the service, if the employee departed from the organization, employee paying some compensation to the employer is merely payment, not a consideration, because the employee not getting in return anything benefit. There is no reciprocity. Payment with reciprocity is consideration. In the given case, payment without reciprocity, there is no consideration. Reciprocity means one exchanging with the other. You do something for me, I will do something for you, is known as reciprocity. So the payment with reciprocity is called as consideration. If that is missing, then we can declare to say that, my dear friends, it is not a consideration, it is only a payment. Payment we cannot able to charge unless there is a consideration. So in the given case, the employee does not get anything in return from the employer against payment of such amount. As a result, what here happened here? Here there is very clearly says that therefore such amounts recovered by the employer are not taxable as consideration for the services of agreeing to tolerate an act or a situation. It may be tolerating an act, it may be tolerating a situation. In spite of that, there is no consideration, it is only a payment. So understand, just because of tolerating an act, you should not be charged. Whether thereby there is a consideration flowing, then that will be tax. In the given case, my dear friends, a mere payment by employee to the employer, which is not a consideration, therefore not attract GST. Further, my dear sir, late payment charges or surcharges or fee. Late payment charges late payment surcharges or fee is taxable. Late payment surcharge or fee. Here important point to note. The facility of accepting late payment with interest or late payment fee, fine or penalty is a facility granted by the supplier naturally bundled with the main supply. Therefore, it should be assessed at the same rate as the principal supply. If the principal supply nil rate, this particular late fee payment nil rate. If the principal supply is 12% GST, the late fee also 12% GST. Like that you can proceed. Simple clarification given. This point I already explained to you. In the case where the money taken as a loan, thereby late payment, money is a transaction exempted, therefore late payment also be exempted. If there is a supply of goods, supply of services on credit basis where the payment has been delayed by the recipient to the supplier, in that case the main supply is taxable, then the late payment also be taxable, because the principal supply you refer, if it is taxable, then the late payment charges, surcharges will attract GST at the same rate as applicable for the main supply. Further, my dear friends, referring to you here, see, electricity, fixed capacity charges for power, fixed capacity charges, that means minimum charges has been fixed, whether you use or not you have to pay so much. Such charges will attract the GST. Here the law refers the minimum fixed charges or the minimum fixed capacity charges and the variable and energy charges are charged for sale of electricity and are not taxable as electricity is exempt from supply. The main sale of electricity is exempted. Supply or distribution of electricity is also exempted. If the main supply is exempted, the minimum fixed charges or the minimum capacity charges and the variable or energy charges are also be exempted, the meaning of it. Further, my dear friends, circular of the CBIC elaborated in the given case, cancellation of air tickets, cancellation of train tickets, bus tickets, thereby for cancellation charges charged by the supplier, in that case is taxable. Here it refers cancellation charges would attract the GST at the same rate as applicable to the class of travel. What is the rate applicable for the class of travel? That rate is applicable even for cancellation charges, because tolerating an act. Further, my dear friends, here I am presenting furthermore, if there is non-refundable charges, the amount, here you refer, the amount forfeited in the case of non-refundable tickets for air travel or security deposit, or earnest money forfeited in case of the customer failing to avail the travel, tour operator or hotel accommodation services, etc., should be assessed at the same rate applicable to the main service or main contract, as main service or main service contract. That means to say that cancellation charges, non-refundable charges, as the case may be, will attract the GST at the rate which is applicable for the main supply of service. Further, my dear friends, referring to you here, after this, furthermore presenting one more important circular in the given case. Referring here to you now, dear friends, there is a circular 172/2022, namely circular number 172/04/2022 dated 6th July 2022. CBIC given a circular. Say, what is the question here? Whether various perquisites provided by the employer to its employees in terms of the contractual agreement entered into between the employer and the employee are liable to GST. This point presenting here as follows. Look here, my dear sir. Employee benefits, one way or the other, perquisites provided by the employer to the employee based on contractual agreement, employment agreement. Under the employment agreement, employer agreed to provide to the employee so many benefits. The benefits availed by the employee in the name of the perquisites, whether it is attract the GST. The law of the land here says that in the given case, my dear friends, Perquisites provided by the employer to the employee in terms of contractual agreement will not be subject to GST, because whatever may be employer and employee relationship, which is Schedule 3 transaction, supply excludes. Therefore, in the course of employment, employer whatever provided to the employee is not attract the GST, except in the case where gift given to employee, where the amount does not exceed rupees 50,000 in a financial year. If exceeds rupees 50,000 in a financial year, that might be attract the GST, except that remaining all cases, employer provide the services or employer provided the benefits to the employee in the course of employment does not attract the GST. Further referring to you, my dear friends, from here, if you refer here further, sale of land and building, which is Schedule 3 transaction, supply excludes unless it covers under Schedule 2 para 5 clause B. Now, in case of sale of land or ready to occupy properties, ready to occupy buildings, after obtaining completion certificate, supplied is not a supply. You are aware of that, is immovable property. Here the law of the land, referring here a circular 177/09/2022 tax research unit TRU dated 3rd August 2022. What it says, which is explaining here, is as follows. Now look here, my dear friends. Sale of land after some development, such as laying the drainage pipes, water pipelines, electrical cable lines, land leveling, in all these cases, in such cases, in the given case, drainage pipe laying, water pipe laying, electrical point laying, leveling of the road, this and all has been carried out when there is a sale of land taken place. Sale of land along with these activities will attract the GST. These activities, sale of land principal supply not attract the GST, resulting that these particular activities goes hand in hand with the main supply as ancillary. Ancillary also not attract GST. If you refer here, you understand this point. Referring to you in the given case are as follows. In the given case, my dear friends, referring to here as follows. Look here, in the given case is also a sale of land and hence does not attract GST. But on the other hand, if you refer here, services provided for development of land, such as drainage laying, drainage pipe layings, water pipe laying, laying of electrical cables, leveling of road or land, these are activities only carried out by a supplier of service to a builder promoter, which will attract GST. In the given case, which will attract GST, shall attract GST at applicable rate for such services. Further referring to you, my dear friends, one important clarification of the CBIC with regard to tolerating an act or a situation, or refraining from an act, or agreeing to do an act. Refer here. An agreement made builder and the prospective customer, the customer who wanted to buy that particular property. Here what happened? Forfeiture of earnest money by a seller in case of breach of an agreement to sell an immovable property by the buyer not taxable. Meaning what? There is a ready to occupy building, sale of that building not attract the GST, because immovable property, Schedule 3 transaction. Now a buyer intended to buy that property, made agreement with the builder or a seller, by giving advance payment of 10 lakhs. The building is worth 100 lakhs, paid 10 lakhs advance money. Thereafter, the buyer not in a position to mobilize the funds, therefore he cancelling that contract. Seller says, as per the contract, on or before so and so date, if you are not going to make the payment of the balance money, the earnest money, the amount paid earlier will be forfeited. So I am forfeiting, like that seller said. So buyer accepted. It is a cartons agreement. In spite of that, it does not attract the GST because the main supply itself not attract the GST. That's why forfeiture of earnest money by a seller in case of breach of an agreement to sell an immovable property by the buyer not taxable. Further, my dear friends, allotment of natural resources where there is a cancellation taken place. Allotment of natural resources, cancellation taken place. Forfeiture of earnest by government or local authority in the event of a successful bidder failing to act after winning the bid for allotment of natural resources also not taxable. See, natural resources. See here, what we can call here cultivation of fisheries and natural resources. For example, I am telling you, our natural resources with regard to land, for example, coal mine. Coal mine bid called by the government. There are so many companies approached for the bid. One of the company, let us X Limited, won the bid. After winning that bid, that company not able to take up the assignment for obvious reasons. Thereby the government charging some charges or whatever the bid amount paid earlier is forfeited by the government or local authority. Such forfeiture amount with regard to natural resources, with regard to immovable property, especially natural resources with regard to immovable property, where the forfeiture of earnest money from winner of a bidder, that bidder is not in a position to take up that assignment. In that case, that forfeiture of earnest money is not a consideration, is only a flow of money, not attract GST, only it is a payment, hence not taxable under the GST. Got the clarity, my dear friends?